Good morning and welcome to the District of Columbia Court of Appeals. We have two cases on our calendar this morning. The first is 24 CV 942, MedSTAR Georgetown Medical Center et al. Versus David S. Kaplan. Counsel, whenever you're ready.
Morning, Your Honors. May I reserve 5 minutes for rebuttal? Thank you. May it please the court, Derek Steichler on behalf of the appellant hospital. I'd like to begin with just a 90-second overview of the three errors that bring us here today.
You might want to just jump in. We're familiar with the case. We've read the briefs. We're ready to go.
All right. I think that the greatest problem is that in a case with no claim for economic damages, the verdict sheet allowed a double recovery by providing separate lines and separate awards for physical injury and emotional distress. No one on either side of this appeal has yet found a case anywhere in the district, anywhere in the United States that has ever allowed this separation of duplicative
Do you have a
damages.
case where it's been disallowed? Because it didn't seem like any of your cases were on point.
The cases that come closest, we don't have this precise scenario, but the Second Circuit's Rounds decision, which was at 211 F3rd 185.
Is that in your brief?
Yes, it's in our reply brief. It expressly found reversible error in separating awards for pain and suffering and emotional distress.
But that's
Right.
very distinguishable. Go ahead, go ahead.
After you.
That's very distinguishable, right? I mean, that's the point. The point there is that pain and suffering includes both physical injury and emotional distress. And so having pain and suffering as well as a separate line for emotional distress could lead to duplicative recoveries, whereas other cases have said that pain and suffering, and the restatement and as well as other secondary sources have said that pain and suffering branches into two or more sub issues, which are physical pain as well as emotional injury. So that it's a distinguishable case to me.
Well, they may be characterized as sub-issues, but they are inextricably intertwined sub-issues. We have
But the point is that the verdict form disentwined, if that's a word, disentangled, separated out these two concepts that I think conceptually are distinct. I mean, I think I can understand that physical pain is different from emotional distress and that I can have one without the other, or I could have both.
Well, that's a different proposition, and certainly there is.
Why is it a different proposition?
There's lots.
Isn't that the crux of it, right? Like, if we want to make sure that the verdict form does not invite duplicative damages, we want to make sure that the questions on the form don't overlap. And we have a verdict form that says, if you think that there's, breach of the national standard of care and there is causation and you get to damages, you can award damages that fully and fairly compensate Mr. Kaplan for past and future physical injury, past and future emotional damages. And so we've got two different figures for these things. And I'm trying to understand, why would that be conceptually confusing to a jury?
There's no part of physical injury that is not upsetting. They cannot be pulled apart in that way.
Why is that? I donate a kidney. I do it freely. It hurts. And I'm not, the surgical procedure is painful, but I'm happy to do it.
And that
I give birth to a child. It brings me great joy, but the immediate physical sensation is painful, right? You can have pain separate from emotional distress and vice versa. And it just seems like conceptually, these are two different things. And the jury could have said, we look at Mr. Kaplan's experience. We think that he had physical injury and we think he had emotional distress or harm. I'm just not understanding why you think they're conceptually different. And I don't see any sources supporting your argument that they are actually conceptually inextricably intertwined.
Well, I think I'll just on many levels. First, none of those pains are recoverable. A joyous pain of a donation or a birth is not recoverable in tort. There
That's
is,
not my point. My point is just you can have physical injury without emotional harm. You can have emotional harm without physical injury. And so it is fine, it would seem, to list both on a jury form and not risk duplicative damages.
I would challenge the premise that there is recoverable harm for physical
Based
injury
on what?
that is unrelated to.
I guess I just don't understand, like the restatement that Judge Schenker mentioned. Restatement second of torts defines compensatory damages that may be awarded without proof of pecuniary loss to include A, bodily injury, B, emotional distress. Seems to just lay out that you can have compensatory damages for two different things. Restatement third also separately defines physical injury from emotional distress. So the restatements, my understanding, are sort of encompass kind of the generally accepted understanding. And yet you're up here telling us, no, these two concepts, they just can't be distinguished. And I just don't see what you're telling me that, but I don't see a source or an authority for that proposition.
Well, I'd agree
And it doesn't seem like a matter of common sense to me.
they're not synonymous. If it was a matter of common sense that they were separable, we would have a court in the District of Columbia that does separate it, or at least
Wait, we're here. We
no court has ever done that.
Right. But maybe that's because no one has ever been asked. And so now we have this case and we could decide this. I mean, is there anything precluding us from deciding that no, conceptually, these are different? And actually the restatement recognizes them as being different. So we're going to hold this is fine.
The restatement does not recognize them as separately awardable. And these standards lay out several different types of emotional
I don't,
distress.
I'm quoting from the restatement second.
Yes.
Compensatory damages that may be awarded without proof of pecuniary loss include compensation for A, bodily injury, and B, for emotional distress. So I don't understand. I mean, yeah, it doesn't say you can write the verdict form this way, but certainly it supports the proposition that these are two distinguishable concepts. And it seems to me totally the logical next step that you could write the verdict form this way.
Well, in addition to the Rounds case, which I think is instructive, we have the Illinois Supreme Court's Powers case, which listed again several elements from the Illinois pattern jury instructions. And it said, yes, these are separate elements. They are not synonymous.
Right.
But it
In
is
that
error
case-
to put them together.
In that case,
To put them
jury-
together.
I'm sorry, to list them separately on the verdict form. Thank you, Judge.
the instruction to the jury was that the nature, extent, and duration of the injury, the court said that it was error to instruct the jury that the nature, extent, and duration of the injury was separately compensable from pain and suffering.
And disability.
Right, but that's just, they're not the same words, right? Like just on the most basic level, physical injury, emotional distress. But I feel like we've gone over that. I guess I also have a difficult time understanding your argument in light of the instruction that the jury was given that I don't understand. MedSTAR didn't object to the damages instruction that was given to the jury, correct?
No, it did. The itemization it objected to.
No, that's the verdict form.
Yes.
The actual damages instruction was discussed, actually, I believe the afternoon before.
Well, there was a request for a curative
Right, it was-
instruction.
No,
was-
I'm talking on April 11th, after the defense rested, the parties discussed the jury instructions, and there's a brief mention of the damages instruction. But it seems like everybody's fine with whatever. We don't have what was submitted. Our record is incomplete, so it's hard for me to tell. But it seems like whatever the damages instruction was that the court gave was the damages instruction that everybody signed off on April 11th. On April 15th, I think there's a long weekend. That's when the discussion of the verdict form occurs. But then the jury is given the instructions
Mhm.
And in the damages instruction, the court gives an instruction that in large ways mirrors what the verdict form says. The court instructs the jury, and again, it's seemingly without objection, that the jury may award damages for any of the following harms that you find defendant's negligence or wrongful conduct caused. Number one, the extent and duration of any physical injury sustained by plaintiff. Number two, the effects that any physical injuries have had on the overall physical well-being of the plaintiff or the plaintiff may experience in the future. So that's sort of past and future physical injury. And number three, any emotional distress that plaintiff has suffered in the past or may suffer in the future. So that's the second verdict form. And there's no objection. Again, the damages instruction was discussed before the verdict form and seemingly was consented to and then was delivered. And I'm having a hard time understanding how we think the verdict form was prejudicial if that's the instruction that the jury was given without any objection.
Because the instructions are not to separate the two. And I want to emphasize, we're not saying that the pattern jury instructions are wrong or that it's wrong to read the pattern jury instructions to the jury.
This isn't the pattern jury instruction.
Correct. But to illustrate though, in pattern jury instruction 1301, it allows awards for disfigurement or deformity as
Right.
well
I
as,
agree with you. It would be wrong to deliver the pattern jury instruction or to list everything in the pattern jury instruction on the verdict form. I agree with you. And the court agreed with you. The court said, the trial court said, we're not doing that. But I will list separately physical injury and emotional distress.
which are both contained in subsection 3.
Its instruction to the jury.
In physical pain and emotional distress are both contained within subsection 3 of 1301. I would argue that if a jury were allowed to itemize disfigurement and humiliation as separate lines, those words are not synonyms, those words both appear in the pattern jury instructions. It is clear as a matter of law, those are recoverable elements. You can recover for disfigurement, you can recover for humiliation. You can also recover for embarrassment. What we're saying here is you cannot separately itemize them on the lines because that invites the double recovery.
But the question is,
The question as to whether somebody was in fact disfigured or not, but maybe there was evidence that the person was nonetheless humiliated. I mean, that's not the case before us, but I'm just
Certainly.
thinking about, I mean, you can think about this kind of conceptually, which is the way we kind of been talking about it right now, but doesn't it really have to be looked at more in terms of the case and the evidence in the case? And along those lines, I mean, when you look at the verdict form, physical injury, emotional distress, I mean, I think frankly that just from human experience, people understand these to be different kinds of harms that people experience. But what do you make, Mr. Steichler, of the fact that the jury in this case, in filling out this form, awarded different amounts for each? Doesn't that actually indicate that they viewed them as different things and not as duplicative?
Well, I think it suggests, and obviously we can't get into the minds of the jury, I think it suggests a confusing verdict form, which invited a second bite at the apple and invited a double recovery.
But was there ever any jury, there wasn't a jury note or question about any of this, was there? To
Correct.
indicate confusion
Correct.
on the part of the jury?
If a jury is invited to give a duplicative award, it will do so and can do so, not necessarily will do so, but in this case, it was invited to give a duplicative.
okay, but the question on the jury instruction
Mhm.
is, or the point of the question on the jury instruction is, if the verdict form had only had one line for pain and suffering,
Mhm.
as you now say was required, but the jury instruction that your client did not object to and you did not raise on appeal was given, then the jury could have done the exact same thing and you just wouldn't know it, right? But your view at trial was that was fine, or at least implicitly it was, because you didn't object to the jury instruction and you're not raising it on appeal. So it seems like your only point now is the fact that the court, you're just speaking about the jury verdict form, which I
Correct.
realize is an appealable issue for you, but the jury could have done the exact same thing based on the instruction that you seem to concede was appropriate.
If the jury had been given one line, the instruction is not problematic. We're not objecting to it, and it's fine. It
Right, but
can
that's what I'm
state-
saying. That's inconsistent with your argument, is what
Well,
I'm saying.
I would argue it's not, because emotional distress is a complex, any form of distress. Pain and suffering is a complex concept. So explanation that lays out, it covers humiliation, embarrassment, disfigurement, deformity. These are permissible. All four of those words can be read to the jury. What they can't be given is 4 or 2 separate lines that say how much for disfigurement, how much for humiliation. Because even though they're in no way synonymous, it invites the double recovery. And again, the fact that no court in the United States has ever done this cannot just be pushed aside as well. That's just no
But
answer.
the court has ever said that you can't do this. I mean, it just.
Courts have spoken against
courts
duplicative.
Take the cases that are litigated, right?
Yes.
So if people aren't challenging this, then the appellate courts aren't deciding it.
Well, I think we have to look at the reality of that the plaintiff's bar pushes the envelope of where it can find
So
access.
you would think if the plaintiff's bar is pushing the envelope on this and this is beyond the envelope, that we would see another case. But
Well, and
there are no other cases.
that's the nature of
you've
pushing the
cited-
envelope, is you go into these gray spaces where I mean, these are carefully scripted, carefully rehearsed arguments to be made, particularly with the closing argument, the reptile arguments on safetyism and
Well, I
protection.
think we're
But you
moving
can't
beyond
know
the
that-
verdict form
You
now.
can't
Well,
know
correct.
that no court has ever done this. I mean, that there's no way to know that, because the only way you would know that is if, you can't know.
No
that
one can
because-
find a case where this has been
Right,
allowed.
but it
No-
would have
And
to
that
have
is
been, but it
important.
would have to have been litigated. So there could be 1,000 cases where this has happened, where nobody objected to it and litigated it, right?
Or where they objected to it and, won or lost, but nobody appealed, or they appealed and didn't raise this issue on appeal. But
You're correct that
Do
you
you-
only.
you're out of time
Oh.
on this issue. Do you want to raise any other issue while
Sir,
you're? at the
we would
podium?
argue excessiveness, and the standard for excessiveness, as the court well knows, is shocks the conscience.
Can I ask you a question about that?
Mhm.
So you challenged you sought remittiture in a post-trial motion.
Yes,
And the court decided, your challenge, rejected your challenge in its post-trial omnibus order.
correct.
And you agree that our review is abuse of discretion.
Correct.
And you don't explain to us in your brief to this court why the trial court abused its discretion. I don't think you even discuss the basis of the court's ruling rejecting your remittiture argument. So should we just deem this waived? I mean, we have case law that says when you don't explain to us the basis of your argument, we deem it waived.
Well, the basis of the argument is, well, there are multiple bases, but one is the excessiveness, the other is the improper
No, but
argument.
that's asking us essentially to look at it de novo and say, you Court of Appeals, look at the award and tell us, agree with us that it's excessive. But you
We've never
agree,
asked for de novo review.
right, you're asking for abuse of discretion review,
Yes.
which means that first we have to look at how the trial court exercised its discretion, except that I didn't see in your brief where you actually discuss what the trial court said about your remittiture argument
Well,
and why the trial court abused its discretion in rejecting your remittiture argument. It just seemed effective, even though you adopted the standard of abuse of discretion review.
Mhm.
Effectively, it seemed like you were asking us for de novo review because you don't discuss the trial court's ruling. So I'd ask you to speak to that.
the trial court's ruling is that a $4 million award on these facts for this case is reasonable. It's within the realm of reason. If the court says that sounds reasonable, I'm fine with it, then we've lost that point. We argue it is unreasonable.
But
as a
we
matter of
don't,
law.
I mean, I think that's Judge Easterly's point, not to speak for her, but we don't.
You don't
engage-
review it de novo.
And so we don't determine for ourselves, the three of us sitting up here, whether it was reasonable or not. We determine whether the trial court abused its discretion in determining whether it was reasonable or
And-
not.
And the inquiry into abuse of discretion is whether this award shocks the conscience, is so excessive that it shocks the conscience and therefore, as a matter of law, is
Well,
acceptable.
sorry,
The court also had more to say, didn't just say, oh, I think it's reasonable. It also looked at the factors that we have said and other courts have said the trial court should look at. So for example, did things happen during the trial that was there undue appeal to the sympathy of the jury? I mean, the trial court talked about all these things, right?
Correct. It's
So how did the trial court, look at this, analyze it in a way that you say is an abuse of discretion?
It's the number that is a staggering award. On the facts of this injury, this number is insane. It is off the charts. And if the court disagrees, we've lost that point. So I would like to address, if I may, safetyism and the improper appeals. This was a case where in closing arguments, 10 separate references were made to safety and protecting the patient. This, again, is a very well rehearsed, very well crafted reptile strategy to put in the juror's head the incorrect higher standard. And it's particularly pernicious and dangerous, and it's taught to plaintiffs' lawyers around the country, do this, it will get you more money, because it sounds reasonable to a jury. Should your doctor keep you safe and protect you?
But wasn't that said in relation to the national standard of care?
Well,
As to
both.
how long it is, quote, safe to keep people on steroids?
At one point, that did happen. And that's the nimble dance that's going on by a very sophisticated plaintiff's counsel to sort of step into this area, which you can get away with, and then push the envelope into things you can't get away with. What's impermissible here is when the plaintiff tells the jury, it's Dr. Mattar's job to protect this patient. That is a naked misstatement of the law. It's deliberate. It is intelligently and deliberately given. It says they didn't protect David. And when the defendant objected, plaintiff argued to the court that there was no problem because, quote, it's all about what to do to make sure the patient stays safe and avoids harm.
so
That,
counsel,
if I may finish the last sentence, I apologize. She says that's what their job is. These are fundamentally wrong,
Yeah,
being given
counsel-
both to the judge and the
counsel,
jury.
sorry, we're
Yes.
low on time. So in the closing, counsel did put this in the framework of the breach of the national standard of care. Be that as it may, assume that we agree with you. MedSTAR asked for an instruction to the jury that, quote, said they are to rely on the jury instructions for what is the actual national standard of care. And the court gave the jury an instruction that said, quote, you are only to consider the standard of care and the duty of care and how it's described in 902, 904, and in the jury instructions as I instruct you, okay? And so any argument that you hear that doesn't use those words, you are not to consider that as the law that I have instructed you on. So, and there was no objection to that instruction saying that's not enough. I mean, it seems like you got exactly what you asked for. So what are we supposed to do now? It seems.
That point is made in plaintiff's brief. That is incorrect. On page 1850.
What point is made?
The point that we got the request. that
I
we
just read
wanted.
you your request for an instruction and the instruction that you got, and I am asking and telling you there was no objection to the instruction that you got. So what is it now that you can be heard to complain about because you got the instruction, you got the relief that you requested?
I'll direct the court to page 1850 of the appendix. The court says, and forgive me for paraphrasing, I'm not going to give the
I
curative
understand the
instruction
court
requested.
said, no, the court said, I'm not going to give a curative instruction.
Correct.
Right. But
That's the
the court,
presentation.
right. But how the court characterized it as a curative instruction or not, it's not like MedSTAR asked, please tell the jury that you're giving them a curative instruction, right? What MedSTAR asked for was for the court to tell the jury that they're supposed to rely on the jury instructions about the national standard of care. And the court gave an instruction that told the jury, you're supposed to rely on the instructions about the national standard of care. And then the court actually went one step further and said, Any argument that you hear that doesn't use those words, you are not to consider that as the law that I've instructed to you. So it seems like the error that you raised, you asked for relief, you got relief. What did the court do? We're here on appeal and we're reviewing what the court did. What did the court do wrong?
We asked for a curative instruction. The court said, I will not give you a curative
What
instruction.
different instruction did you ask for that you did not get?
We had made the point that and we didn't articulate this is the form. She didn't say draft up an instruction. I'll look at it. She said, you're not getting one. So we raised the objection. We said this safetyism, this to protect the patient. This is improper. It's inappropriate. We said why it's inappropriate. We said we want a curative instruction. The judge said, you're not getting one. That fully and finally resolves the issue. If the court's going to say that's a waiver, that's among the most aggressive
No,
applications of
it's
waiver.
not- It's not a waiver. It's that you got what you asked for and you asked,
Absolutely not.
you
So
said.
what,
You
So what
asked,
should
I
the
just
court
want to
have
make
said?
sure that the time frame is clear.
Sure.
You asked on the page 1846 for the curative instruction with the language that I read to you.
Mhm.
And then the court said, subsequent to that, I'm not giving a curative instruction, but I will say that, that they have to follow the jury instructions. And then the court gave the instruction that I read to you on page 1855.
And that is inadequate. The law is not meeting
But
the
you didn't
moment.
object to what the court said after the court said it.
I think our objection had been noted and preserved. If the court deems that we were
Okay.
in agreement with the court, then helpless to respond any further. But I think we objected. I think it was preserved. I think we were clear why this is so problematic. The court had the information, the opportunity to make the ruling and said, I will not give you a curative instruction. So that
and
is
what
the
would a
element.
curative instruction have been in your mind?
It would have alerted the jury to the idea that safetyism and duty to protect the patient is absolutely not the standard. That is an impossible standard for physicians to meet.
Right, and the
you were
court said
told-
any words that you heard that are not in the standard jury instruction or the jury instruction I provided you regarding the standard of care, you're to disregard.
Correct. And that's the play of the plaintiff's bar. Say the wrong standard, the consequence is just an instruction, read 1902, read 1904, that's controlling. And if there are no consequences for doing that, that will be the
But you
playbook for
could have
every trial.
asked, you could have said to the judge, tell the jury that they have to follow the national standard of care and tell them to disregard any language about safety, right? That could have been your request. That was not your request. Your request was tell them to follow the national standard of care. The court told them to follow the national standard of care and then went one step beyond and said, and don't regard any language that deviates from the national standard of care.
I don't believe there's an obligation to proffer a specific instruction when the court says, I'm not going to give a curative instruction on the exact issue. And if the court's view is that that has to be done, again.
But perhaps, okay. You know, you talk about things that the plaintiff's bar does. I'm wondering whether there are things that the defense bar does. You know,
No, I'm
this
not
kind of
saying,
vague request.
I'm not saying that parties shouldn't advocate in their client's interest and plaintiffs should try to maximize awards. I'm saying that the law is not meeting the moment. The purpose of the courts is to provide a fair trial for both parties.
Right, and the
And-
courts need to know what a fair trial is based on the advocacy that's taking place in front of them, right? And so for preservation purposes, if you ask for an instruction and the court gives the instruction that you ask for, and then you realize, wait a second, that's not adequate, it's on you to tell the court, wait, that didn't quite do it. We need more, because otherwise we're faulting the court for doing precisely what you asked the court to do, which isn't a good look. The trial judges don't appreciate it when when we as an appellate court say, you're screwing up because you did exactly what plaintiff's counsel asked you or defense counsel asked you to do.
I don't think that's a fair reading of the record. We requested a curative instruction. The judge
okay.
said point blank, I will not give you a curative
If you want
instruction.
to, if you want to sit down,
Sure.
Jerry, and I'm not sorry, that came out wrong. If while we are listening to appellee argue, you would like to look at the span of the transcript,
Sure.
between 1851. And I'll give you the exact pages because I really would like to understand, what I'm missing here. It is on 1850. (1846) is where you ask for the instruction. 1849 is where the court says, I will give an instruction. I just don't conceive of it as a curative instruction. But the court says it will give one. And then 1855 is where the instruction is given. That's the sequence of events, as I understand them, if you want to look at that. Thank
Great.
you.
Well, thank you so much.
We'll give you more time on rebuttal.
Thank you. I appreciate it. Very much.
May it please the court, Alfred Belcour for David Kaplan. And just to complete that final point, Your Honor's citation of the joint appendix is absolutely correct. At joint appendix 1846, and this is relevant. This is the quote. This is what MEDSTAR requested. This is experienced trial counsel speaking. We like a curative instruction to the jury that they are to disregard any suggestion as to the amount of damages that might be appropriate. That's the Colston point. And quote, that they are to rely on the jury instructions for what is the actual national standard of care. That's what we've been talking about. And as Judge Easterly read at 1849, the judge said, and I'm going to quote it word for word, quote, I don't think I need to give a curative instruction. I think what I just need to do is just to remind the jury that the standard of care is found in the jury instructions that I provided to them, and that they are bound by those instructions. Remember what the request was, that the jury is to rely on jury instructions for what is the actual standard of care. The judge said she would do that, and at 1855, that is exactly what she did. And that was done just as the jury was retiring to deliberate. And the judge also added, lawyer's argument is not evidence. And of course, the jury had already been instructed to rest their decision only on the evidence. All this discussion, though, is in the context of this court in the Wheeler case, having said, we see no impropriety in Wheeler's counsel's remarks. And that is at 75 Atlantic 3rd, 283. What were the counsel remarks in Wheeler that was approved by the trial judge and by this court? 6 times in one paragraph, the trial lawyer there spoke of the standard existing to promote patient safety, protect patient health, above all, prevent harm. That language was approved already. And it, as a matter of common sense, of course, that is what the standard is intended to do. Like a warning label, like an expiration date on mayonnaise, it is implementing the rule, first do no harm. So there was no error to apply the law. The judge could not abuse her discretion by applying the law as it exists and by complying with the request that she received.
So, Mr. Belcour, is that how you read or how you understand the trial? Why did the trial court say, or how do you understand that? I will not give a curative instruction.
Of course, I don't know what the trial judge was thinking when she uttered that sentence, or whether her thought changed when she went to the next sentence. But the point is, what did she do? And she said, all I really need to do is tell the jury to follow the instructions. Whether you label that a curative instruction, a cautionary instruction, a further explanation, it doesn't matter what it's called.
I'm sorry, I thought that by your citing Wheeler,
Wheeler.
that you were implying that what the judge was saying is, I see no need for a curative instruction because I don't think that anything untoward has been said that needs to be cured.
Right.
However, of course, if you're asking me to say that you should only listen to what the national standard of care is, of course I will do that because that is the law.
Well, we're talking about what is the discretion inherent in a trial judge to manage the trial, and this
Right.
was a 10-day trial, to manage a trial consistent with what the law is. Would the trial judge in Wheeler have been wrong to say, I'm going to give a cautionary instruction that the words safety is not in the standard form instruction? I would not argue that that's an abuse of discretion, because it's not in the standard form instruction. But we are talking about what is fair argument to point out to the jury, why is there a standard of care? What's its purpose? Its purpose is to protect the patient, to assure that care is rendered soundly, consistent with medical science. And why is a doctor bound to comply with the standard? To protect patients. It's for public safety. There's nothing wrong with that fair argument. Is it the language of the instruction? No. But this is what a trial is. This is advocacy. So I am going to now go back to the first point that was argued. And the notion that there's no reported decision, who knows, it may have been so frivolous it was unreported if it was litigated. The notion that there is no reported decision, talking about what we have in this case, it doesn't really go far enough in this jurisdiction. Because in this jurisdiction, this court in Bank took pains clearly and expansively in Whitman versus Walker, Hedgepeth versus Whitman Walker Clinic, to discuss the circumstances in which a claim only for emotional distress, where there is no physical injury, can be brought and compensatory relief awarded. The court will recall that was a case where a physician told a patient incorrectly that the patient was infected with HIV virus. And for any number of years, the patient lived with the belief that he had HIV. It didn't ripen into AIDS, but it was HIV. He had emotional distress from that, but no physical injury. So the question is that a litigable claim? And Bank, the court said yes. And also said, in response to a defense argument about the difficulty of proving emotional distress when there is no physical injury, we've already crossed that bridge.
Okay, so you could have emotional injury without physical injury, but can
Right.
you have physical injury without emotional injury?
I suppose if the patient is so inured to it that there's no conscious harm that is not physical pain, but I doubt that that would be true. And certainly when there is physical injury, there may be what's called the parasitic damages of emotional harm. But to say that they can't be segregated has been rejected in this court. Because the juries, we trust the juries to make that determination. We trust the jury applying the instruction for subjective harm of apply your own life experiences. We trust the jury to think, well, I like to jog. What if I could never jog? I like to swim. What if I could never swim? I like to play a musical instrument, guitar in my case. What if I could ever play that? And then the juries are able to place a value on that. That's what we asked them to do, and that's what this court has said they can do. There was a question and colloquy about whether there was objections by MedStar to the standard form instructions. And the record references are Joint Appendix 1623 to 45, 1715 to 36, and 1740 to 57. Once again, 1623 to 45, 1715 to 36, and 1740 to 57. No objections to the standard form instructions listing the damages. And furthermore, this trial judge was mindful of the need to avoid overlap. For example, the instructions listed that the jury may award damages for extent and duration of physical injury. But it also said the jury may award for the effects that any physical injuries have had on the overall physical well-being of the plaintiff. And then, of course, the instruction said that the jury may award damages for emotional distress. And the court did not put a line on the jury form for the effects that any physical injuries have had on the overall physical or well-being of the plaintiff, or that plaintiff may experience in the future. There was no line for that. Why? Because they're wrapped into the first one, which was for physical injury, and the second one, which was for emotional distress. And similarly, the court specifically rejected plaintiff's request that there be a separate line for disfigurement, even though, as there was evidence, the scarring has caused Mr. KAPLAN to feel embarrassment. It affects his social interchanges. There could have been a juror who was mindful of that in making this award, but there was not a separate line for it. There was no overlap. The cases, counsel mentioned the Rounds case, the Second Circuit case applying New York law. The most recent Illinois case is this Marks Miller case, 90 Northeast 3rd, 1066, which MedStar cites. Both of those pristinely show one line for emotional distress, another line for pain and suffering. There's no overlap. We have here an apple, which is physical injury, an orange, which is emotional distress. Both are fruit. Metaphorically, both stand for pain and suffering. What MedStar argues is that the jury was requested here to put a value on this apple and put a value on this fruit. That's not what they were requested to do at all. Also on this issue, and obviously we don't put all our eggs in a waiver basket on the verdict form, but at JA 1741, MedStar Experienced Counsel did say we're satisfied.
Yeah.
We're satisfied. Now, I know if I'm...
That was after they had objected, and it seems like it was in response to sort of a different question of, now we've printed the verdict form out based on what we've discussed. Does this look right? And MedStar said they were satisfied. I have a hard time reading that as an abandonment of the issue that they had already preserved.
That's not an unreasonable reading, but it's a reading by people who were not there.
Why on earth would they do that? I mean, they've preserved the issue, they've made their point, and why would suddenly 2 pages later in the transcript would they just say, walk away?
No.
It doesn't
But one
make
thing
any sense. It seems like it's a clear, now we're looking at it in black and white. Yes, this reflects what we've just discussed. You know, subtext, we still maintain our objection, but you don't have to, you know, repeat your objection over and over and over again.
No, you certainly don't. But I have 2 things I'd like to say in response to that. Yes, that's a reason. 3 things. Yes, that's a reasonable reading of the cold record, which is the only thing we can do here, appellate counsel in this court. But the trial judge who was living this trial, who heard it in person, and heard that we're satisfied statement made after we have no objection to instructions except for those we previously made, so counsel knew how to preserve. The trial judge in her post-trial opinion had this sentence, quote,
Yes, I know the trial judge pulled it out. It seems like she pulled it out of context. And I know that we're here on the cold record, but we do like to get to the merits when we can.
well, and I'm arguing the merits, and that's what I argued first,
Yes.
and I think we're clearly right on the merits. So I will not belabor this point, only to say that that sentence of the trial judge at Joint Appendix
Yes, I mean,
1880.
arguably the trial court is going back and looking at the cold record just like we are. And I think perhaps misremembering how things.
You might not want to put any of your eggs in that basket.
I'm sorry?
You might not want to put any
I'm
of your.
taking my eggs out of that basket.
Okay.
And you are closing in on the end of your time. So if you want to give us any concluding remarks.
This was not an inflamed jury who did not deliberate. According to the cold record, the jury on a Monday wanted to stay late to reach a resolution, was granted permission to do that, deliberated for 2.25 hours, could not reach a resolution. The next day was Emancipation Day, a day off. They did not deliberate. They came back and deliberated for another 1.5 hours and then did reach their result, which by any stretch and the extent of the past and future injuries are recounted in our brief. But $2.5 million for the pain that this man has suffered and will suffer, with a total of 17 possible surgeries on his hips. 7, not 17, 7 possible surgeries on his hips. And the emotional distress of $1.5 million for what he has suffered when he felt he was in limbo and not being treated properly, and what he has to experience in the future with the anxiety of not doing what he likes to do. The testimony was, these go to his core issues of his being, the jury heard. That's from the sister, that were taken away from him. $1.5 million for that is not a verdict that is not entitled to the deference that the trial court gave it, and to the double the deference that this court gives the trial court and juries in cases of this sort. With respect to any other argument that has been made, we rest on our briefs and urge that the correct result here is to affirm the judgment below.
Thank you, counsel. Mr. Steigletter, we'll hear from you for a few minutes.
I think the fate of this appeal hangs on Judge Shanker's question
Oh, boy.
of whether
Putting a lot on me, isn't it?
you can have physical injury without emotional distress. I asked myself the same question in preparation. I suspect Judge Eastley asked herself the same question. She came up with childbirth and donating an organ. Anaerobic exercise is painful, can be extremely painful. Playing football can be very painful. Lifting weights is painful, but none of that is compensable. And here we have to look at, in this case, there was an award of $2.5 million for physical injury that was separated from emotional distress. And I say it has to be.
They have to be, why does there have to be just an absolute bright line? Why isn't it enough that you can say, I can sort out in my mind that this person was hurt in 2 pretty distinct ways. One, there was just the physical pain of their condition, right? The hips deteriorating, having to do these painful surgeries, all of the rehabilitation that happens afterwards, and any continued, pain that persists, future surgeries that might have to happen. And then I can distinctly envision just the emotional distress of this entire event of feeling abandoned by doctors, getting inadequate care, and the real upshot of it, I think this is from closing argument, being robbed of your youth, right? I mean, as someone who is squarely in middle age, I would take my body from 20 years ago back, sure, and be able to run and play soccer and do all those active things that don't feel very good these days. And to say suddenly, age 35, fast forward, you have the body of a 55 or 65 or 75-year-old, because you don't have hips anymore. That's a loss, and that's an emotional loss, and I get that. Why do we, I mean, sure, they're linked, they're connected. One happened as a result of the other, but it doesn't seem to me that it's necessarily duplicative to say, I can envision this type of loss and I can envision this type of loss. And jury, we want you to think about each of these losses and give numbers for each. And as Judge Ruiz pointed out, the jury did give numbers and they were different numbers, right? So why is that so obviously duplicative? I mean, you don't have any cases, you don't have any horn books. And so you're sort of relying on, I guess, kind of common sense, but it's not making sense to me to say this necessarily was a duplicative award. They were awarding, pain, they were awarding emotional damages that was already subsumed in the physical injury.
Well, I believe we do have cases in Rounds, Marks, Miller, and Powers, but
Different language, just different language. I mean, I just can't get beyond that. And you can try and persuade me that it's the same, but
it's not identical. I agree.
It's not
on all
identical.
fours,
And-
but
and as I said at the beginning of my very long-winded question, physical injury, emotional distress seems like two different things.
well, my response would be to then ask, what part of Mr. Kaplan's compensable physical injury is not also upsetting, is not also
Right, but
emotionally distressing? There's none.
I get that they're connected,
There's none.
but I just described to you how there are two different buckets.
Nothing you described was a physical injury that was not upsetting to Mr. Kaplan.
Okay, so I guess my question is, and I don't mean this to sound flip, but so what?
That's what makes them duplicative.
What-
That's why
but-
no
but
court
that's-
does this.
that's-
But wouldn't that have happened if the jury verdict form had only said pain and suffering?
Hmm.
Then the same thing would have happened, right?
Meaning what?
Meaning
2.5.
that Mr. Kaplan suffered physical pain and injury. And you're saying that that necessarily entailed or came with it emotional injury.
Correct.
And the jury would have done the exact same thing and might have done it
It-
even to a greater extent, right?
Could you please explain what you mean by the exact same thing? With one line, they would have put 4 million or
Yeah.
2.5?
No, well, I'm not just talking about the numbers. I'm saying conceptually, if your point
Okay.
is that someone who suffers physical injury in this type of situation necessarily suffers emotional injury, and the jury is told to award pain and suffering damages, then the same problem that you're identifying is going to happen. It's just not going to be spelled out in a verdict form.
And arguably in this case, I mean, it gives you an insight onto the jury. So that the jury had awarded $2.5 million for physical injury and $10 billion for emotional distress. You could say, wait a second, right? Like this emotional distress award is completely, has no foundation, and we can zero in that it's the emotional distress that they're focused on. And we can tie it, as Judge Ruiz said, as we have to the evidence at trial and say, there was barely any evidence about his emotional distress. I mean, in a hypothetical case, one friend called him one time and he said that he was sad. That's not enough for a $10 billion award, right? But that's not what we have here. We have robust testimony about his physical injury. We have robust testimony about his emotional distress, right? Which was linked to his physical condition, but was its own thing. And we have two separate lines on the verdict form for the jury to say, well, we're going to award him this amount for this and this amount for that.
Correct. But through all this, we've never identified a physical injury that Mr. Kaplan experienced that was not emotionally distressful for
Well,
him.
but
They
let
go
me go
hand in
back
hand.
to Judge Shanker's point,
Mhm.
which is an instruction was given. You agreed with the instruction, right? About damages. That could be a.
The instruction on damages was legally correct.
Right, and the verdict form identifies two of the items that were in that instruction, right?
Yes.
Somehow you think that that identification of those two items separately might have led to duplicative award. Now, I do also want to point out that one of the instructions that the trial court gave had to do with the verdict form itself, and it says, the form is not evidence in this case. Nothing in it should be taken to suggest or convey any opinion by me as to what the verdict should be. Nothing in the form replaces the instructions of law I have already given you. Now, if the judge is saying, look to the instructions, you say, the instruction is okay. How was the jury misled here?
The jury's misled because they were given a verdict form that invited a duplicative award. The cases that we've cited, which are not on all fours with this case, all clearly stand for the proposition that there is such a thing as an impermissibly duplicative verdict form that invites a double award, that invites double counting. And I would emphasize that in the pattern jury instruction 1301.2 allows for awards, and this could be read to the jury, for the effects that any physical injuries have on the overall physical and emotional well-being of the plaintiff.
Did you ask for that instruction to be read?
No, and it's not a matter that they didn't get that instruction. That instruction shows what we're talking about, that is why these are duplicative, because emotional and physical well-being stemming from a physical injury are the same thing. These are not apples and oranges, they're overlapping. And I thank you so much for the incredible amount of time you gave. I appreciate it.
Thank you.
Thank you.
For all your arguments. Thanks to both counsel, and this case will be submitted. Second case on our calendar this morning is 23 CF 196, RAKEEM Willis versus the United States. Counsel, when you're ready.
May it please the court, Stephanie Schneider on behalf of appellant RAKEEM Willis. I'd like to reserve 2 minutes for rebuttal, and I'd like to start with the expert issues and then move to the inattentive juror issue. Rule 16 requires the government to provide a written summary of its experts' opinions and the bases and reasons for those opinions. The judge reversibly erred in admitting Agent Shah's CSLI testimony without requiring compliance with the rule. The generic discovery letter and draft maps did not inform the defense that Agent Shah would opine that the differently sized wedges represented the approximate location of the target phones, or that he had created these maps and the wedges using ESPA and CastViews, software which determined the sizes of the wedges based on unspecified preset parameters. In addition to hamstringing the defense's ability to test the merit of Agent Shah's opinion through focused cross-examination, the inadequate disclosure infected the judge's Rule 702 analysis. Without knowing what Agent Shah would opine and why, the judge lacked a firm factual foundation for his reliability ruling. And sort of to just look at the two pieces of notice that were given. The first was the September discovery letter. It was generic. It was a recitation of background principles about how cell phones work, and a proffer that the expert would interpret the call detail records he analyzed.
And so, counsel, was an objection made by your client to that letter?
No, but by co-defendant's counsel, Mr. Winston's counsel, and under this court's case law, that preserves this case for appellate review. This court has held that where the issue is preserved for appellate review because it was raised by a co-defendant, fully litigated and decided below,
Is that I mean, are those cases analogous when we're talking about a specific Rule 12 requirement that requires pretrial motion? Have we ever attributed the lack of something like that to, or allowed a co-defendant's filing under Rule 12 to serve, to preserve the issue for a co-defendant?
I mean, I didn't find specific cases on point that have explicitly consider that, but I really do think it's analogous. And I think sort of the history of how this litigation goes sort of makes that clear. So initially, the notice that came out from the government was given to both defendants, right? So the letter, the draft reports, it went to Winston and Willis. At this point, no one has specifically invoked, Rule 16. Then Mr. Winston files a Rosser letter invoking Rule 16, citing Murphy Bay. He does not get any additional discovery, any additional notice as a result of that. He files a motion in limine, alleging a Rule 16 violation. There's 2 colloquies in front of the court where this is, argued. It's responded to by
Right, it's
government
just so
counsel.
often that we see, where one co-defendant picks up an issue like this, we see the other defendant saying, well, we want to join, right? They don't necessarily add value to the litigation, but they just kind of ride on the coattails. And I understand that didn't happen here.
That didn't happen
Correct.
here, but it also didn't happen in Williams, which is the case we stated in our brief. That's 966 A seconded A47. And what the court said in that case is it looked like defense counsel was simply asleep at the switches. There was no sort of strategic reason.
Okay, so then you're just arguing for forfeiture rather than waiver at that point, right? Not actual attribution of the objection to your client. I mean, if the excuse is that their counsel was asleep at the wheel.
So what I think what that case said is we are not going to, enforce the preservation rules, against Mr. Williams, where the issue was teed up for the court, for the judge. The government had an opportunity to respond. I mean, these are the things.
But you could imagine a case, and I know you addressed this in your brief, I think your reply brief maybe, that in this case, there was no reasonable strategic reason that Mr. Willis wouldn't join the objection here. But you could imagine a case where one defendant would have some strategic reason, right? Right. So how are we supposed to say that in certain cases, a co-defendant's objection is enough to preserve it for another defendant, and in other cases, it's not?
Well, I think that's what Williams says. I mean, I think it's saying that where there's no strategic advantage, there's no plausible strategic advantage to have been gained by not joining the motion, we are not going to enforce the preservation rules. And the reason is because they're not meant to be punitive, and it wouldn't be in the interest of justice. Now, I agree with you that if there was, it might look different if we could see a strategic reason, if we could see some sort of advantage, but that's not this case. I mean, Mr. Willis's counsel didn't put on an expert. He made clear back in July he was not going to call an expert. He doesn't actually put on an expert, right? So there's no advantage to be gained.
I don't want to direct where you go with your argument, but can I ask you this? You mentioned in your brief, and I think you mentioned in your opening, that the Rule 16 and Rule 702 Motorola issues are intertwined. I mean, can we address the Rule 702 issue if we do not agree with you on the Rule 16 issue, either as not preserved or on its merits?
Yes, I mean, I think you certainly can, because I think our Rule 702 claim is that the judge lacked a firm factual foundation because he did not know, he did not have a basis to know what the opinion would be.
And that's even if we assume that the Rule 16 disclosures were either sufficient or you didn't preserve an objection to that.
I mean, that's right. I mean, we very much disagree that the Rule 16 disclosures were sufficient, because I think the bases and reasons, were never disclosed. But I think, if you disagreed with us on preservation, it remains the fact remains that his opinion, what Agent Willis testified to, right, was that the wedges indicated an approximate area of where the call happened. And he never provided to anyone, the judge did not know, like, what was his basis for that opinion. He did not know how how were those choices made. And I think I want to emphasize that when these call detail records come from the cell phone company, they tell us, what tower and they tell us what sector of the tower and the location of it. They don't say anything about the location of the phone. They don't say how far the phone could have been, how big a wedge should have been. That's the product of some sort of analysis, choices, decisions, the bases and reasons, right? In this case, what we learn at trial for the first time is that that's the result of some program called ESPA and CASPES, and apparently there's parameters that can be adjusted, and typically it's done one way. I mean, the judge doesn't know any of this, and he doesn't know what the expert is going to testify to.
Before we jump into the 702, just really quickly on the Rule 16. So I think the Rule 16 disclosure said something about software. And I guess I'm just wondering, what is your best case for saying this Rule 16 disclosure is not enough?
So I think our best case is it doesn't provide the necessary details. So like Miller talks about why you need sort of necessary details. What I think if you actually look at what is said about software, what it's saying is, this is, I believe on slide 2, is it's saying that, software is used, to plot the towers that were activated. I mean,
I was actually looking at like
Oh.
the Rule 16 letter, right?
Sure.
But maybe,
Okay.
maybe I should be looking somewhere else. And I really don't want to
Sure.
divert
And
you
I
too
think
long.
if you look, I mean, our reading is that at most it says that software is being used to sort of plot the towers that were activated. I mean, certainly that's true, but the import of Agent Shah's opinion wasn't just what tower was activated. It was what could be inferred about the phone's location based on that tower activation, right? It's very different, right? If it's, what the cast agent said in Hill, which is a Seventh Circuit case, which is, oh, the phone could be 5 miles away. That's very different than if it's, in a narrowly bounded, much smaller wedge, or at least, that's the approximate location, and accurately depicting sort of the magnitude of the distance it could be. I mean, that's very different, right, in terms of the probative value of that evidence. And what was not provided is like how those determinations were made. And those are the bases and reasons for his opinion. Like, why are the wedges, some are small, some are big, sometimes it looks like the phone is much closer to the tower, sometimes farther. Like, that's his opinion. What were the bases and reasons? And it turns out that he just, he plugged in some information into a computer program that we never learned about. The judge doesn't know anything about it. We don't know, the judge doesn't know. Certainly defense counsel in terms of Rule 16 can't prepare a focused cross-examination, and look at things that defense counsel would want to do, right?
So
Like, what are,
moving on to the 702 question. I mean, the judge sort of says, oh, well, I do know, because I've seen this a lot. And so why is that problematic?
yeah, well, he does say that, but I think that's, as a factual matter, cast agents, everyone's assuming that they're identical. I feel like the colloquies read as though they all say the same thing. The FBI cast agents are identical, but that's not what the published cases suggest. I mean, sometimes they come in and they say the wedges, all that they signify is the direction that the phone is from the tower. In this case, he's saying the wedge is the approximate area. There have been other cases. We cited Bernie, which is a New Jersey case where a cast agent comes in and has very similar maps. And he says, based on these maps, I can opine, it's a half mile. The phone must be a half mile within the tower. They're saying all different things, but they're also using different methodologies. I mean, this expert says himself, sometimes we do drive tests, right? He says, I could have done this by hand. In this case, it turns out he used ESPA, not disclosed. But if you kind of do a Westlaw search, you'll see that sometimes they use a different software program called Trax. I mean, they're not, I think the point
So
is that,
how much digging or how much disclosure about, because like you say, it sounds like they just get information, they feed it into some program that then spits something out, right?
sure.
And you had the sense that the people doing themselves may not really know what that is, right? And how it works. So, what is supposed to happen then? Is it that defense counsel is supposed to say, well, we want to call an agent, we want to be able to cross-examine the person who really knows? You have to present,
No,
is there some analogy, for example, on DNA and how much had to be disclosed or explained at that time in those cases?
So, I mean, I think our Rule 6, I guess the Rule 16
I'm
case
sorry, I
law.
thought we were talking about 702. Because.
Sorry.
Oh,
In terms of
I mean,
Rule
they
7.
are because I take it what you're saying is that regardless of Rule 16, under 702, the judge has an independent obligation to look into certain things specific to the case.
That's correct.
Right.
So he needs to assure himself, right?
Right.
That the methods and principles are reliable and that those methods and principles that the expert relied on have been reliably applied to the facts of this case.
To the
Here-
facts of this case.
So
right.
here that's so 702C is just looking at the reliability of the methods and principles in general, and 702D is looking at the application to the facts of this case. So in this case, there was a complaint. It was Rule 16 and Rule 702. What defense counsel said, this is Mr. Winston's counsel says, I don't know what this expert is going to testify to. I don't know his bases. I can't tell the disclosure is insufficient, but I'm worried, I'm worried about its reliability. We don't have enough information, Judge. I think you should, do a Daubert hearing because you don't have enough information to rule on the reliability of this. He says this, and it's true. We don't know. We don't know that it was this ESPA. Nobody knows. And what the judge seems to say is, it's routinely admitted. It always comes in. Everyone knows. They just use the computer. But the fact that something is routinely admitted, if it hasn't been vetted, by this court or by other courts, the specific program, we don't have any assurance it's reliable. Like what proper vetting would look like would look at questions like, okay, so it's based on ESPA. Okay, has ESPA been tested and validated? What's the known error rate? Has it been subjected to peer review, outside of the law enforcement community? Like those are the sorts of things one would look at in a 702 C analysis when trying to determine whether just, plugging some called detail records into a computer program and having it spit out an answer, right? Whether or not that is reliable, like you would, but the judge doesn't know that that's what they did in this case. I mean, he can't just, and I think he can't just say it's always admitted, therefore it's reliable. And I think it's worthwhile to note that the judge doesn't say like, I've done a Daubert hearing in the past. He doesn't purport to rely on, another superior court judge who's done an extensive Daubert hearing on any sort of CSLI analysis, let alone the one that happened here, which was ESPA. But
Maybe it
that-
doesn't matter, but would you agree that at least perhaps 702A could be based on the court's prior experience or the court's reference to other trial courts having accepted this? The
Sure.
issue really, it comes down to maybe C and D,
Yes,
maybe
we are focused. I think our claim here is focused on C and D. We aren't really contesting A and B. We are saying that the judge did not have enough information to, issue a reliability ruling on the principles and methods in this case. Because one, he didn't know what they were. I mean, he doesn't even know, it's very vague what the actual opinion is even going to be. It's it's sort of very slippery. Like, what is this agent even going to say the wedges represent? But we know now from trial, and we know what he said. We said it's the approximate location of the phone. And we also know that the principles and methods that that Agent Shaw used to arrive at that conclusion, the judge doesn't even know about them. He doesn't know about ESPA. It turns out, according to Agent Shaw, that there's some sort of parameters and agents can adjust them. We don't know what adjustments were or weren't made, what the defaults were. I mean, it's all coming out, at trial. But all of that is sort of relevant to the question of, are the methods that he used to form his opinion, are they reliable? Did he reliably apply those methods to the facts of the case? And we're not offering an opinion on whether it was or wasn't. We're saying the judge didn't have enough information to make that determination. And his ruling was based on sort of an erroneous understanding of his gatekeeping rule. Like, it's not just that something is routinely admitted. Stuff could be routinely admitted without being challenged. And it's not just because even if some type of CSLI has survived, scrutiny under 702 C and D, given that these agents offer such widely varying opinions and widely varying methods, you need to be sure that the one here has survived that sort of scrutiny.
What's your position on how much needs to be said? I mean, could a trial court simply say, I've read the disclosures and the report, the draft report, and just basically pare it back? And I know the court didn't really do this here, but arguably it did. Just pare it back the language of 702 A through D. and say that it finds that they're satisfied?
I mean, I don't think you could just find that 702C is satisfied unless an analysis that looks at the factors that 702C look at has been done, either by him or by other judges looking at the same methods, right? And so that's when I was, referring to things like whether the program has been tested and validated, the known error rate, peer review. Those are sort of the standard Daubert factors that judges look at in assessing 702C sort of for the first time.
And I
Now,
take it this sort of wraps into your Rule 16 argument, because since there wasn't a disclosure of what the actual methods were, it's hard to say that the court implicitly found them reliable because he wouldn't have any way of knowing what they actually were. I mean,
that's right. I mean,
Yeah.
that's correct. I mean, the way I read his ruling, he is basically just saying, CSLI, like broadly, generally is admitted a lot of the time in court. And he says, I'm not prepared to act differently than what the vast majority of judges in this jurisdiction and the federal system have done. But he's not being specific about what was done here. And I think it's important that not all CSLI, not all
well,
cast
isn't
agents
that,
testify
isn't
the
kind of
same.
that the point of the Daubert rule, is that the trial judges are supposed to be prepared to act differently depending on the facts of the case?
That's exactly right. But, and here he's sort of skipping the inquiry entirely. I mean, his ruling seems to be, I've let it in before, I'm gonna let it in again. It seems to come in routinely. I'm not gonna act differently, but he's not asking any questions that would really assure himself that the principles and methods, and again, that's like how the conclusion was reached about the sizes of the wedges, how far or close this, approximate location of the phone is. He's not doing anything to ensure himself that those methods that were used here were reliable, because he doesn't know what they are. And it's frankly even vague what the actual opinion is going to be, based on the disclosures. And I see I'm out of time, and I have not mentioned the inattentive juror issue. I'm happy to touch on that briefly or save that for rebuttal.
It's up to you, counsel, if you'd like to talk about it for a couple of minutes, or if you want to rest in your briefs, I defer to you.
Okay, I will just make a really brief statement, if that's okay. Throughout opening statements, the presentation of evidence and summation, juror number 2 repeatedly closed his eyes, slumped his body, and hung his head, including during the visual presentation of the CSLI maps. Despite personally observing this behavior and the juror's own admission that he closed his eyes for numerous portions of the trial, the judge refused to replace him with an alternate because he denied sleeping.
So counsel, is your argument then, it would just seem to be where your reply went, it kind of doesn't matter whether or not he was sleeping, his eyes were closed, and this was a very visual case?
Yes, I think that I think that's exactly right. Like his eyes were closed. It's a visual case. You can't pay attention to what's on the
Do you think
screen.
that argument was made to the trial judge, right? Or was it
Yes.
more that it's, wait, he's sleeping, we know he's sleeping?
I think both were made. I think it started with sleeping because at the openings, he was slumped over and jerked up. And then there were 6 colloquies. And so it sort of evolved as it went. But as it went on, the focus switched to his eyes are closed while things are on the screen. Things are being changed on the screen. His eyes stay closed. Things are being pointed to on the screen. They stay closed. And I think the argument is made, based on his slumped body and drooping head, it looks like he's sleeping, but at a minimum, he's not paying attention. He is not, and that argument is specifically made. He, at this point, has not paid enough attention to this trial to fairly and fully deliberate. So I do think both arguments were made, but I think the one that's sort of, dispositive is the inattention. I mean, and I think I just want to also say that sort of all the surrounding context really cuts against the notion that this is some sort of attentive juror who pays attention with his eyes closed, because it can't be done to visual evidence that's being pointed to, like CSLI, and 2, the head slump, the slumping, the droopy head that everyone sees, including the judge, that is not consistent with paying attention. But I think the more, the more powerful point is like, how do you pay attention to testimony that's entirely based on looking at slides, pointing to things with your eyes closed? It can't be done, and it was clearly erroneous for the judge to suggest that it could. Thank you.
Thank you, counsel. We'll give you a few minutes in rebuttal.
May it please the court, David Goodhand from the United States. Good morning. If I could take the issues quickly in reverse order, I'll start with the juror Rule 24C issue with the court's permission. The trial court did not abuse its discretion in denying the Rule 24C motion. And I think the record betrays assiduous attention to this issue. And I think that's the discretion that is afforded the trial court. And I think the chronology is important here. And if I can just borrow 35 seconds, I might allay any concern that this court has about the attention the court paid to this issue. We have the trial start on November 25th, a Tuesday. There was a brief reference to the nodding of the juror, and the court took the defense counsel's advice. Let's just mention breaks. A week thereafter elapses, November 3rd, November 2nd, a Wednesday. That's when we have the first sort of focus on anything relating to the juror. And there were differing opinions for sure. The defendant said, I saw eyes closed, head nod. AUSA said, he's been attentive, I haven't seen that. And so what the court does at that point, I think this is critical. And again, just to borrow 40 seconds here, the court exercises its discretion, deploys the gold standard. I'm going to ask the juror what happened, what is going on here. And the court very carefully walks the juror through, first, have you been sleeping? No. Judge says, no. Have you been paying attention? Yes. And the fourth question is, have you been listening? Yes. So, again, we have a very assiduous attention, gold standard voir dire. And then critically, the next day on Thursday, defense counsel, again, raises again, I've seen some nodding, and the court denies it again. This is very next day after the voir dire and the implicit crediting of the juror. The very next day, the court said, well, I'm going to have an ongoing assessment of this. And that's it, November 3rd, page 73. The weekend unfolds, 3-day weekend. On the next Monday, counsel raises some nodding, head down during the ballistics expert testimony. Counsel at that point actually concedes, quote, I'm not going to say he was asleep. That's 11-790, and suggests that's a reasonable inference. The court listens to defense counsel and says, do you want me to interview the juror again? And that's 11-7 transcript at 91.
So, I'm sorry, you may have hit your 40 seconds or not, but
I'm sure I exceeded it, Your Honor. That's my
I may not have given you your full time to explain the chronology, but my question is, if we can accept that the trial court did what it's supposed to do procedurally, right? And that goes a long way under abuse of discretion review, but it can't go all the way, right? I mean, the court can still get it wrong. And there's got to be a perhaps sliver, a small universe of cases where the court gets it wrong, despite doing everything it is technically supposed to do. And why is this not that case? I mean, I'm not trying to make light of a very serious case, but I'm kind of reminded of when my wife gets annoyed that I'm falling asleep during a movie that we're watching, which inevitably happens every night. And I say I wasn't sleeping and I was snoring and falling off the sofa. And it's like, I'm sorry, like I was sleeping, the court says, let's say we discount what defense counsel said and we discount what the prosecutors said, because they're obviously on different sides of the aisle on this. And we just take what the trial court said, its own observations. And I'm drawn specifically to the point where the court says, yeah, I looked and his head was falling. I looked again, his head was falling again. And I looked again and his head was falling again. I mean, that is that's the definition of nodding off to me. And that seems to be a problem. And if we accept that there's a perhaps small universe of cases where a juror seems to be inattentive and perhaps sleeping, perhaps not, and that would be enough to call the juror unable to perform or disqualified. And that's, I guess, a separate legal question for you. But why is this not that case?
This is not that case for several reasons. First, I don't disagree with the notion. I think Johnson permits a court to assess whether the trial court judge exercised its discretion in a reasonable and rational manner. I feel like that might be the sort of narrow window you're talking about here, where this court might say, there wasn't a rational and reasoned judgment here when you have the evidence that you had. That's not this case for several reasons. First, of course, we have the two voir dires where the juror says, I wasn't sleeping. And if we can look at, for the most part, the parties weren't on very different sides here. The prosecutor said, I saw some eye closed, I saw some nodding. Defense counsel said, well, I think the reasonable inference from that is sleeping. And so the court bridged that gap and figured out what was the reasonable inference by going directly to the source, going to juror 2. Is that a reasonable inference, juror 2? He didn't ask it this way, of course, but is that a reasonable inference? Were you sleeping? Were you paying attention? Have you nodded off? No, 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 no. And then clearly implicitly credited the jurors.
Right, but are we ever going to have, so if a juror answers yes to that question, then they're probably going to be excused,
Sure.
right? So we can only be here in this court when we're talking about cases where the juror said no to that question. And isn't a juror almost always going to say no to that question? And so that can't be the standard, that if a juror denies sleeping, I'm not trying to be funny, but if a juror literally falls over in their chair and is snoring on the floor, and then the trial court says, were you sleeping? And they say no, we cannot say that that had to be accepted, right? Of course, your answer is going to be, that's not this case, but it seems awfully close to that case.
I disagree, and a couple points, if I may. First, my opponent's own case, the case from Texas, the defendant, the juror actually conceded that he was dozing off. So first of all, I just want to disagree with the premise that a juror who is nodding off, he's not admitting to a homicide, so number one. Number two, okay, let's look at the credibility finding here and ask ourselves, what corroborates that credibility finding that I would suggest it's implicit in the court's two rulings? Several things. First, this was a 2-week trial. Nobody else made a report about that juror. There were many people in that courtroom, no report. Another piece of corroboration, the court was assiduous with the instruction, pay full and careful attention to this trial. And then 3 times encourage the jurors, tell me if you need a break. We presume jurors follow their instructions, not a word said by this juror or any other juror in adherence to those instructions. Number 3, again, this juror actually conceded, yeah, my eyes have been closed. So
and
I think
that's where I want to jump in, Mr. Goodhand. If the juror is saying, yes, my eyes are closed, is it okay for a juror to sit through a trial with their eyes closed?
Well, sit through a trial is the key phrase there, Your Honor. We don't have a record that denotes this juror kept his eyes closed the whole time. And in fact,
but don't we, it seems to me that a lot of the focus of the court's focus, it was trying to figure out whether the juror was asleep. And I'm just wondering, no one could fault the court for not paying attention to this issue and giving it the attention that it was due. But it seems like maybe the focus on figuring out whether the juror was asleep was, too high a bar. If the court and everyone else was noticing that the juror has their eyes closed and is nodding off, whether or not they have technically reached REM sleep or not, they can't see what's happening. And this was a very visual case. So why isn't that just enough to say, look, sure, the court did the right thing, had 2 voir dires, instructed the jurors to take breaks if they needed to, but when faced with evidence that this juror was sitting through much of the trial with their eyes closed, he really should have excused this juror, whether or not they were asleep.
Again, I'm gonna disagree with the notion of much of the trial.
Right.
And I want to focus on the transcript because I think this is important. Much of my opponent's discussion focused on the cell site information. Those were the maps. There was a long PowerPoint, and you could tell there were occasions that both the prosecutor and the defense counsel noticed there. But critically, at page, this is the November 3rd transcript at page 108. The AUSA talks about on the direct examination of Agent Shaw, this is an exact quote, on the direct examination of Agent Shaw, I was paying attention, and all the times I saw him, he seemed engaged. So, again, we have a factual record here that supports the trial court's ruling, number one. Number two, my second point is, just as the AUSA said below, and the courts have recognized, you can listen and concentrate with your eyes closed.
Sure, but this was a visual case in large part, right?
I'm certainly not going to
There were
dispute
no
that.
eyewitnesses to listen to say, this is how this crime went down. It was mapping how, these phones were moving around the city based on visuals.
Sure.
Can I just ask you one quick question? You refer to the court's credibility determination with respect to this juror who may or may not have been sleeping. What was there an actual credibility determination?
Well,
I mean, maybe you think it's just implicit that the court was saying I credit this juror, but but maybe you don't have to say that, right? I mean, is that how you read the record, that there was a credibility determination?
Well, I understand express credibility finding to be what we all see in bench trials every day. I expressly credit Judge, Witness Smith. We don't have that here, but what we have is equally good, I would suggest. 2 times the court voir dire juror number 2. 2 times immediately after the voir dire is concluded, the court says, first time, November 2nd, page 58, I don't know that I have the evidence to support that judgment at this time.
Right, but why can't we I mean, it seemed like the government was sort of suggesting earlier, when you have a juror who denies sleeping, you have to go with that, right? And there's kind of no room to discredit that determination. And so why couldn't we interpret the judge's statement of, I don't have enough to dismiss this juror to be a similar kind of like, well, he said it.
Because
my hands are tied.
well, first of all, he didn't say that. And again, this is why I started the argument off with the assiduous attention. The court listened to the parties, asked for their opinions, asked for their sightings. He paid careful attention to this. And he had 2 voir dires at the end of which he said, I don't have a basis. I see that as an implicit credibility finding. I can't imagine a scenario where a court would voir dire a juror and the juror said, yeah, you know what, I was dozing off. And the court ignored it because there was other evidence. Here, not only do we have the exact opposite. We have the juror on 2 occasions saying, I wasn't sleeping. And then we have the abundant corroboration that I have proffered, the AUSA's observations, the instructions that we must presume were followed, and the lack of any other reports from any other person. Final point, Your Honor, and I apologize, I just want to circle back around to, Your Honor quoted the court quite appropriately. And this was, I'm sorry, court's indulgence. I just want to make sure we have the full context of that quote. Here we go. I'm sorry. This is the Thursday, November 3rd transcript at page 107. Yes, the court, again, consistent with his ongoing assessment, says, I saw his eyes closed, his head went down a little further. But critically, the back end of that quote is, and I looked back at 12:40 and his eyes were open and he was paying attention to everything that was going on. So, even the court's observations were, again, the necessity of the voir dire to sort of answer the question of, is this a reasonable inference, I think is what separates this case from any other case that I've seen. Sort of the gold standard was deployed twice. We have the implicit credibility findings, and we have the significant corroboration coupled with, a final point on this is, this is the legal point. I focused on the facts, but the legal point is that, Hinton was a very significant sea change in the law here. Before Hinton, Thomas said, broad discretion, jurors are fungible. Hinton said, no, jurors are not fungible. Once the jurors impaneled and we have a sitting juror, then they listen to the evidence and we cannot treat them as fungible. And so what I would suggest Judge Ryan was adhering to was a stringent standard that Hinton articulated, which is it's a narrow grant of power, it's a demanding standard, and it's a far more limited scope for the trial court's exercise of discretion. So I would suggest we have a judge who's perfectly, concisely adhering to the legal standard articulated by Hinton and Hobbs.
But would you agree, and I'm assuming we all want to move on to the 702 question, but would you agree as a legal matter, and I know you don't agree as a factual matter, but if a juror is either asleep or inattentive in a meaningful way, or is closing their eyes during critical visual evidence, that could legally satisfy the disability / unable to perform standard?
Of course. I mean, Samad is clear. Prolonged inattention constitutes unable to perform your duties pursuant to Rule 24C. I don't disagree with that at all. I'm simply suggesting that we have a legal standard that says you've got to be careful. You can't treat these as fungible items. And that's true for both the defense and the United States. Hinton is quite clear on that. Coupled with, I'll note that Batten itself says that a citizen has a right to serve as a juror. So, the court has a very sort of multi-layered analysis here, very carefully calibrated to these idiosyncrasies of the situation. I would suggest you can't read this record and not understand the court precisely applied the law to a very, very significantly supported factual record. I'd like to turn, if I could, to the Rule 702 issue.
You may, don't look at the clock.
I'm sorry?
You may, don't look at the clock.
Don't
look at the clock.
Oh, I'm sorry. Yeah. So of course not. No, I believe me, I've been in this court long enough to understand the clock is admonition, if you will.
Yeah. Maybe not even
It's
that.
aspirational.
Yes.
Aspiration, that's a better word. Before I turn to the Rule 702 issue, I want to focus very briefly on this issue of waiver. And I think this is an important point with respect to the Rule 16 argument that my opponent is proffering here. The plain language is you get summary from the government's expert if you request it. We don't have that. The defendant doesn't disagree with that. So we don't have plain language adherence on this record, number one. Number two, let's understand the natural implications of my opponent's argument. It would, I suggest, encourage significant gamesmanship. Let's imagine a 5 co-defendant antitrust criminal trial. And one defendant says to the government, hey, give me your summary of The Economist. According to my opponent's argument, the other 4 defendants would be able to draft off the summary of the opinion and the means and the methodology provided by the government and not give over to the government The Economist that those other 4 defendants might be proffering. So significant gamesmanship, I would suggest, emanates from the logical consequence of the violation of the plain language here, number one. Number two, in this case, we have, I would suggest, a sort of poster child for an example of what gamesmanship we're talking about. Even Winston, the co-defendant, when he asked for Rule 16 disclosure, it was a single sentence in his motion in the factual background, and that's at A186. The June 17th, 2022 hearing rolls around to discuss the motion, to have argument on the motion. Not one word uttered on Rule 16 and the adequacy of disclosure by co-defendant Winston, let alone co-defendant Willis. Then finally, at the July 28th, 22nd hearing before Judge Ryan, things have shifted. The government has filed its own request for expert testimony. Co-defendant Winston, and I think this is incredibly telling, says, in response to the government's motion, because co-defendant Winston hadn't provided any maps of his purported expert cell site analysis. At that point, at page 14, co-defendant Winston, again, Willis entirely silent, said, I could have filed that myself, almost conceding that I really was going through, I really didn't file a Rule 16 discovery request. And so now what we have here is co-defendant Willis raising, chapter and verse on the things that were missing purportedly from the government's disclosure.
Right, but so say it's not preserved, say we agree with you, wouldn't we at worst be reviewing for plain error then, not waiver? Right, I mean.
Certainly, I would think at a minimum, we're talking forfeiture, but the cases I've cited, they say waiver, and
Right,
that's.
but we had, there was we had a discussion about what Rule 12 means and whether waiver actually means waiver in our Chu decision or in my separate opinion about Chu. I mean, I just think it's hard to read Rule 12 as really meaning you waive something if you don't raise it. So I think we're in plain error territory, and assuming that's the case, why wouldn't this be plain error? I mean, how on earth would a defendant know what the methods, the principles and methods are that are being used by this expert in this case vis-a-vis the cell site tower?
I think there is plenty of information provided, in particular as to the opinions. At A95, the government says agent will explain which cell towers were used for the calls and text placed from those numbers during the time period. Then, of course, we have the maps. And as 6 federal authorities that I've cited at pages 33 to 34 and note 27 of my brief, as 6 federal authorities have said, those maps equal visual representations of the estimated locations of a defendant's phone at various points relevant to the case. That's the opinions part of Rule 16. As for the bases and reasons for the opinions, again, if you look at A62, points out call detail records have been provided. And it says the call detail records document the network interaction to and from the target cell phone and the cell tower and cell sector site which serve the phones. Then exhibit then same page A62, it explains when used in conjunction, the call detail records with all those facts coupled with the provider information of antennas and where they are. When those two things are used in conjunction, it illustrates an approximate location of target cell phones when they initiate contact with the network.
But isn't the question of how does it estimate the approximate location? I mean, isn't that like really the core essence of it? And what I understand counsel for Mr. Willis to be saying is we had no idea. Lots of analysts do this in a variety of different ways. Turns out here he's using some software that we've never heard of, that we've never seen, that we've never had an opportunity to test. And so, I mean, this is the Rule 16 issue, and I think we should get to the Rule 702 issue in a minute, but why at a minimum shouldn't the Rule 16 notice tell counsel, hey, and we're using this software, so that counsel then can go around and do some investigation and hire an expert and say, what do you think about this software? Have you seen this software? Is this reliable? How does this work?
Well, a couple of points. First of all, the court, of course, this notice did, as was brought out during my opponent's argument, the disclosure does reference software. It does not identify the software, sure. But my opponent spent a lot of time talking about he knew nothing about the wedges. Exhibit 531, this is A65. The shaded arc solely indicates the general direction of radio frequency signals.
This is the trial exhibit, right?
Yes, but it was also provided, this was part of the maps that were provided to the counsel beforehand. At A202 in the United States' opposition, quote, the pi wedges illustrated in the expert cell site analysis maps were meant to illustrate an approximate area and not the exact coverage area of a particular cell site tower being used.
Right, but the question is, how do you approximate the area, right? I mean, yeah, everybody knows that, or I mean, I guess it's very clear that it is approximate, but the question is, how is it approximated? And what's the error rate, and all of these things that you might want to know to figure out if this is a reliable method of tracking a cell phone, and in this case, really tracking the alleged movement of an individual, to and from a murder scene.
In the ideal world, of course, there might have been reference to, for example, the software and perhaps, the expert of the defendant could have gone down that road. A couple of points though on that. First, there was no reference to the missing software that was alluded to in the Rule 16 disclosure by co-defendant Winston. Obviously, Willis didn't say a peep about this. Number one. Number two, so no motion to compel in the 4 months that unfolded after the notices. Number two, even at trial, there were only 2 objections lodged during trial, and they were both to leading questions by the prosecutor. And we know why the defendant Winston didn't complain about the missing, computer program, because defendant Winston got a significant concession from the government in cross-examination. And this is at page 67 of the November 3rd transcript. This shaded arc is not the actual coverage of that particular tower, correct? That is correct, page 67. Question, this is just an arbitrary distance that the computer put in, correct? Correct. This is just an approximation of the coverage area. So what we have here is sort of why I started with waiver, and
Maybe that goes to, in a plain error analysis, the prejudice component, but anyway, it still seems like we're in plain error land because no one, maybe Mr. Willis didn't object, maybe Mr. Winston didn't object to this particular deficiency, but I'm still struggling to figure out why this is an error that's plain, because it just seems like not enough for a Rule 16 analysis, particularly when, and I'm going to shift you over to Rule 702, when you're asking the judge to fulfill their gatekeeper function. And it's just not clear to me how the judge would do that if they don't understand what the analyst in this case is doing.
well, assuming we're in plain error, I'll try to keep this short because I know you want to talk about Rule 702. I'm happy to do that. If we're in plain error context, then I would just direct the court's attention to the 4 federal cases at pages 33 and 34 and note 29, where I cataloged what was provided to the defendants in those cases. And in all of those authorities, they said that satisfied the basis and foundation of the opinions. I think that answers that.
Okay, so on 702, you did not argue lack of preservation in your brief, if I'm correct on that.
That's correct.
And I also don't think Mr. Willis raised anything about 702, but you haven't raised that.
Your Honor,
We're on sort of.
look, I read this court's opinions. I've seen that in the context of these types of situations where one co-defendant has raised it, I've seen the same case authority that this court is familiar with, that we're not gonna be draconian about that and hold the feet of the defendant to the fire. That's why I didn't raise it.
Okay, so I guess straight to the heart of the matter, how did the trial court's analysis here satisfy at least 702D?
The trial court's analysis satisfied 702 in a number of ways. Most critically, when we step back and look at what Daubert says the judge has a task of ensuring that the expert's testimony rests on a reliable foundation. The court answered that question, reliable foundation, by accessing 2 fonts of information. One, his significant experience in 12 to 15 trials involving, excuse me, if I can just get some water. Thank you. Apologize. Court used 2 fonts of information. I've sat through 12 to 15 trials involving cast agents, and I know what Agent Shaw is going to say. He's a cast agent. I've been provided the same notice that was provided to the defendant, so I can compare and contrast what Agent Shaw is going to say, his proposed testimony, and compare it to the 13 to 15 trials that I sat through involving cast agents. And in those 13 to 15 trials, we know of one of 2 things. Either the defendant didn't challenge the reliability of that testimony and thus conceded its reliability, or there was an actual assessment of reliability by the judge and the court let it in.
Right, but the reason I focused on,
D.
homed in on 702D, right, is that I mean, the last phrase of the subsection is to the facts of this case. And it almost seems like by definition, you cannot satisfy that requirement by reference to prior cases.
Well, you can, because again, what we have here is the judge understanding via most critically the maps, the judge understanding this is what Agent Shaw's proposed testimony is. I also know what the basis for his opinion is, the methodology, mapping software. And so the judge, when asked to assess whether or not this, to the reliable principles of methodology, the facts of this case, he knows the facts of this case. He's got it. And so he can compare and contrast the prior testimony about the opinions.
But we have to know something about how he did that, right? I mean, there's literally zero reference to how he conducted that analysis. And perhaps it could be short, perhaps it could rely to some extent on prior cases, but this case has its own facts necessarily.
And he
that are
understood
unique.
those facts and he
We
did
don't-
his analysis.
But we don't know that. I mean, he
That's
said nothing.
I'm sorry to interrupt. Your
But
Honor.
he said nothing, and we've required, at least specifically under the Motorola standard rubric, that we have to have something to go off of. And I mean, in this case, I'm thinking, for example, that, in other cases, you might have someone walking around close to a cell tower. In this case, we're talking about a car. That's different. That's unique. I don't have enough of the technological, wherewithal to understand how that's different exactly, but we don't know what the trial court said about how, in this case, with the Lexus driving from point A to B to C to D, this expert used CLSI to map out how he tracked the Lexus going from point A to point B to point C to point D, for example, right?
Again, I disagree. I think the inference, again, stepping back to Johnson, in the context of use of discretion, this court can infer the reasoning if it feels there's any sort of vacuum that needs to be filled in. This record supports inferring the reasoning of the trial court. He had 12 to 15 trials. He knew how other cast agents had testified. He knew what Agent Shaw was going to say, and he compared and
Can we
contrasted.
go back
do
to
we
the
know
12 to
anything
15
about-
trials? I mean, we
Yeah.
know nothing about them, right? And you posit, well, there are only two scenarios. One, that it was challenged and it was admitted, or two, that it was conceded. I mean, there are other options, right? There's C, which was, actually the core of the evidence against the defendant was elsewhere, and the cell site testimony was add-on and no one really cared about it. And so defense counsel didn't litigate that because really the core of the case was the informant's testimony or, the confession or whatever it is, right? So it came in, but it wasn't central to the case. Or another option is that defense counsel, was ineffective by not challenging it, didn't realize or didn't have the resources or, whatever it is, but it's not necessarily an implicit acceptance that this is reliable. And we have no idea how it was litigated in these cases. I mean, it feels like we're being asked to import all this extra record evidence, and we don't even know what that evidence is that's in the trial judge's head, that he doesn't explicate, he doesn't describe, and just says, I've seen this before. I mean, this is like Fry, but worse. It's not general acceptance based on other experts. It's just kind of general acceptance around the courthouse. And that just seems completely antithetical to what Daubert and Motorola held.
I disagree. We know exactly what this court said because he said it at the June 17th hearing. He went into that hearing and he said to the government, hey, tell me what Agent Shaw is going to say. And then he said to defense counsel, do you have problems with that? Defense counsel identified the two tripwires that the courts are unanimous with respect to cell site information. Two tripwires. One, you can't purport to give a precise location. And number two, you can't suggest that the antenna is always the closest to the phone. So defense counsel identifies those at the June hearing. And the court turns back to the government prosecutor and says, is your expert going anywhere near those? Absolutely not. Carefully caveated testimony. That's a phrase that the prosecutor uses regularly. And this is critical. The court then turns back and the court says, well, I'm going to enforce those limitations. Those are the limitations dictated by a decade's worth of case law. Tripwires relating to precise location and location of the cell phone, and an antenna is always the closest. Those are the tripwires. Those are the ones identified by the defendant Winston
It
at that
sounds
hearing.
like you're making a preservation argument now.
I'm sorry.
Right? It sounds like you're making a preservation argument now, right? Like
No.
the limitations that the court puts on the testimony, I mean, that comes after the adequate Daubert Motorola analysis has been done. Should happen.
I think
right?
I'm sorry. You're right.
No. I mean, it just seems like what the court is supposed to do in the first instance as the gatekeeper is make sure that it understands what the methodology is that this agent is using in this case. And as we've discussed, like that wasn't in the Rule 16 notice. I don't know how the court would have known that from the colloquy that even you just quoted to us. Like, we don't know what software he's using. We don't know how he's analyzing this. And so, first, that's the first step of the case, is to figure out, like, wait, how is this expert looking at this cell site evidence and plotting out where these phones are moving? And there's nothing in there that sort of describes that in any detail. We haven't heard from the expert. And yet the court is just sort of summarily saying, I've heard it before. And now, so I'm going to sort of jump over this analysis and I'm going to put these limits on it on the back end. But that seems to skip sort of the central part of what's supposed to be happening under Daubert and Motorola.
I disagree. I think the hearing was the Daubert analysis, and to the extent that you're suggesting the methodology is not available in the notice and the disclosure of the maps, again, I would point to A62. The cell sites were input into mapping software using latitude, longitude coordinates provided by the companies, and the cell sites associated with the target phones were located using the mapping software and plotted cell sites.
But what is known about the mapping software, for example?
What
Again, we can look at and have some confidence that there was an analysis that the use of that software was appropriate in this case and was reliably applied.
I think this mapping software is, again, my opponent never mentioned mapping software. He got a massive concession from the expert about that it was basically an arbitrary software. This notion that because there wasn't a 5-word phrase identifying the mapping software here, when the government was quite clear that the wedges are just approximations.
The more you say that, the more it makes me feel like, how relevant, how probative was this evidence? I mean, you're kind of pushing this to me to think, was this sufficient evidence?
Your Honor,
If it was so general and so approximate and maybe even arbitrary.
Your Honor, my opponent certainly hasn't raised this.
I understand that, but this is a very strange case. Let's start out there. And I think this is part of what Judge Easterly was getting. This is it. This is all the government has, okay? So either it's good evidence or it's really, really weak evidence. And that, I think, is what you're hearing here. There is concern in a case like this that the evidence that the government is relying upon is worth something. And when the judge says, I have a gatekeeping function, I realize that, but you know what? I've done this before, so I don't have to do it again. And then he also says, in any event, I'm not willing to go beyond what others are doing, which to me is kind of not doing what the judge is supposed to be doing, which is supposed to be focused on this case, which might require that you do something different.
A couple of points, Your Honor.
Thank you.
I would disagree with Your Honor's last point. What the court did, based on what I would suggest is a very keen understanding of the case law in this context, was he ensured that the tripwires that the cases have identified, only 2 tripwires here, wouldn't be violated. And then, of course, when he said, those are the limitations I'm going to adhere to, and then he turned to defense counsel, and this is page 22 of this June 17th hearing, He lays out, these are my limitations. The expert is only going to say it's a representation. It's not absolute. It's not even fixed. The phone connected to the cell tower in the general sense. And he turns to a defense counsel and he says, tell me why that is something that is concerning for you. And defense counsel said it's not. Again, if that's the limitation of the expert testimony, that's fine. My point being that everybody was on the same page. Everybody understood a decade's worth of case law in this context involved these tripwires. That's when you trip over into unreliable testimony. And the court could take that case law, take his experience with his prior cases and say, okay, I know that these are the guardrails. I'm not going to let you go that way. Got an assurance from the prosecutor, you're not going to go that way. My opponent hasn't suggested that the expert did go that way. And he turned to defense counsel and he said, is that sufficient? Is that enough? And defense counsel says that's fine.
Maybe I'm misunderstanding, but I thought Mr. Willis's argument was that the expert did go well beyond those guardrails. And maybe your response is that's not a 702 issue. That's a different issue. But my understanding is that they are.
I'm sorry, Your Honor, I did not read the brief to be that. And in fact, if you go to note 33 of my brief, I say there's been some suggestion that perhaps the guardrails were exceeded here, and I lay out the trial transcripts that demonstrate that wasn't the case. And I don't think you can look at the transcript of Agent Shaw's testimony with the sheer number of carefully caveated testimony and approximations and conclude that we are in Machado territory. That's what I understand my opponent's argument to be. We're in Machado territory. We are not in Machado territory. First of all, I don't think the defendant has raised this, certainly didn't raise it below and make an objection. Oh my gosh, as in Machado, oh my gosh, the agent has tripped a wire. No, complete silence, 2 objections leading. That was it. Number one, and that's because, again, Agent Shaw was careful with that testimony. Machado only enters into this sphere. And by the way, Machado is the single case my opponent cites where a court has said there has been a Rule 16 and or Rule 702 problem. My opponent, that's a long table of authorities in my brief. The cases are consistent. You only get unreliable CSLI if you go past those tripwires. Machado found the agent went beyond those tripwires. Machado, I don't want to paraphrase here. I want to quote.
But is it possible that, go ahead.
I was just going to make a couple points on Machado. First of all, the defendant conceded in that case. The general methodology of collecting and interpreting cell site evidence, and that's 47 F4 at 731 note 2. So the Machado conceded that cell site testimony in general is reliable. The court in Machado only held there was a problem relating to Rule 16 and 702 because, and this is 47 F4 at 732, quote, the admission of the testimony about precise locations of cell phones the expert analyzed was an abuse of discretion. In that case, the agent, unlike Agent Shaw, said the phones were, quote, within a half mile of a tower at the time of the murder. That's 47 F4 at 732. And that the 2 phones were, quote, very close to a particular tower at the time of the murder. And that's at 47 F4 at 7.
I'm sorry, Mr. Gooden. So do I understand you to be saying that so long as the court lays down the rules, the 2 tripwires, it kind of obviates the need for any kind of 702 analysis?
I think consistent with the decades worth of case law, yes. And again, that's when the defense counsel says that's fine, that's the defense counsel agreeing. I understand what these tripwires were. I understand what the cases have said. And again, I want to final thing about Machado, and then I want to make one more point. Same year as Machado came out, the DC Circuit in Morgan said cell site analysis, quote, enjoys widespread use by law enforcement, and quote, courts have generally found it to be reliable and admissible. Here's the point I want to finish with, and I'm happy to, of course, answer any other questions. I talked a long time. I apologize, but Kumo is a very important piece of this puzzle, I would suggest. Kumo says, and this is 526 U.S. at 152, trial judges must have considerable leeway in deciding in a particular case how to go about determining whether a particular testimony is reliable. And it goes on to say, again, at 152, Trial courts need this discretion, quote, to avoid unnecessary reliability proceedings in ordinary cases. This was an ordinary case. That's what the judge said. I've seen 12 to 15 trials. I know what the tripwires are. This case, I've gotten assurances from the prosecutor, isn't going to trip those wires.
But so is your position then that if, I know you don't think this actually happened, but if a trial court doesn't conduct any sort of 702 analysis at all, just skips it, and that none of these tripwires are in fact tripped at trial, that's fine? I mean, I don't know if that's a variation on a harmlessness argument, which I don't think you made.
But if the premise of your Honor's question is that this judge didn't engage in the analysis.
No, I mean, I accepted that you don't
It's
accept that.
completely-
I knew that you didn't accept that premise,
Yes.
but that seems to be where you're going, sort
It would
of.
be a much more difficult case if we didn't have that June 17th hearing. We had the June 17th hearing when the judge says, prosecutor, tell me what Eden Shaw is going to say. Prosecutor says what Eden Shaw is going to say. The judge then turns to defense counsel. You have any problem with that? No, that's fine. That's because everybody understood the judge had just gotten from the government an assurance that Agent Shaw would not go into unreliable territory. That's a sufficient Daubert analysis under Kumo and under this court's case law, I would suggest. I've meandered a long time. I
Wouldn't call it
appreciate your
meandering.
listening, and we would ask that you affirm the trial court's decision below.
Thank you, Mr. Gotand. We appreciate your argument. And Ms. Schneider, we'll hear some rebuttal from you.
All right, thank you. I'll try to be brief. A Rule 702C and D analysis cannot be done without knowing what the experts' methods are. This case, in that respect, is just like Machado Arazo, where the judge erroneously, assumed the methods, assumed the reliability based on different case law. And so
What's your response to the government's argument that there are only two tripwires, everybody knows what they are? The court identified the tripwires and said, don't cross them. And so it's all good.
So we disagree with that. I mean, first of all,
That
there are
wasn't
no-
as eloquent as Mr. Gotand was.
there are no tripwires in this jurisdiction. I start with the premise that this court has never even issued an opinion on CSLI. And it has never said that it is always admissible, no matter what methods are used, as long as the opinion doesn't go beyond certain tripwires. The judge had an obligation to conduct a Rule 702 analysis in this case. He didn't, and we just don't know what the results of that analysis would be because we still, don't know that much about the method to use. I mean, we know ESPA, we don't know that much about it. And it doesn't make sense to say, I guess, my opponent is saying, as long as the judge doesn't cross these two tripwires, all is fine. I mean, that doesn't make sense. Like, what if there's a program and the error rate, most of the time it's an error. As long as he doesn't say it's absolute, it would be fine to rely on it to make the wedges. I mean, that doesn't make any sense. It can't be that all CSLI forever is admissible no matter what the expert does. Surely there is some CSLI expert that is admissible, but it's going to depend on the methods, right, that the expert uses and whether he uses reliable methods. And that should have been tested in this case. It wasn't. The judge just seemed to say, I'm not going to, as Judge Ruiz pointed out, seemed to say, it always comes in, I'm going to let it in. I'm just going to go with that without actually inquiring what the methods were.
But there are only, again, I'm no expert on this, but there are only a handful of methods, if that, right? And so it may be if you're saying the exact proprietary name of the software might be different. I get that, but are there really very widely varying methods in a broader sense?
So I don't know that it's true that it's so narrow. I mean, I can say, we are seeing maps that look very different than the maps in this case coming in, in real time now. Presumably those were done with different methods. I mean, I think it's evolving.
Well,
I
but
mean,
you're
this is
saying
a field that's
presumably, but I
evolving.
guess I'm asking, is that the case? And maybe
I
you
don't
know.
I don't know. I mean, I'm certainly not an expert in this. I mean, I know, at a minimum, we know that there was the ESPA software that they used here. We know that sometimes though, they've just, plotted them on a map like in Jones and not purported to make any representation about the approximate location and just said distance. When they've done that, that's an entirely different methodology. I mean, that was what happened, in Machado Arazo. If you look at that case, the judge was assuming that the testimony would be just like in this prior case, Jones. And in Jones, the agent had offered direction testimony, direction only, nothing about distance, right? And the error was that she just, assumed what the testimony would be, said, oh, well, in Jones, that was reliable. And so therefore, I think it's reliable here. The problem was she didn't know what the methods were. And so there wasn't a firm factual foundation for the ruling. And I think that's really analogous here. I mean, there are different methods that are used. And I don't think that the agents offer the same opinion. We've pointed to numerous cases where they have opined on these CSLI agents have offered very different testimony about what can be inferred about a phone's location based on the cell tower it activated. So I just don't think it's as uniform as the government makes it seem. And if, there are no further questions, I guess we will, rest on our briefs on the sleepy juror issue. Thank you.
Thank you, Ms. Schneider. Thank you, Mr. Goodhand. It is very nice to see you, Ms. Kolb. This case will be submitted and the court stands adjourned.